Hi, it's Lindsay with High Sierra Legal, and today we're going to talk about how to avoid probate. Look at the other video that I've done in my blog as well. We talk about probate, what the probate process is, and why we want to avoid that probate process, because it is quite a nightmare, honestly. As we discussed that, your lack of privacy, the time frame it takes, the court intervention, the cost, all of those things you typically don't want your heirs to go through. So even with the will, as we know now, you still doesn't avoid probate. The will is just the roadmap through probate. So how do we avoid probate? There are several ways. So say, for example, one, you don't have a lot of assets, you don't have real property, you just have a bank account, a car, maybe some investments. Okay, you rent a property because you downsize, you don't own your real property anymore. You just have the basic things: bank account, savings account, investment, vehicle. To avoid probate with those assets, we can put direct beneficiaries on there. What a direct beneficiary is that you are saying to those financial institutions that you want this specific person to have this specific account or car or what have you. And we'll go over cars a little bit here too. So with those accounts, you say you go to your bank account, your unit credit union or whatever it is. You go down there and you have formed this account. You have a checking and savings account, money market account, something like that. You have from a banking institution. When you formed that account, they will ask you who you want as a beneficiary. Oftentimes people leave that blank. Sometimes people put their spouses or their kids, but oftentimes people don't put anybody on there just because bankers don't really force it or really talk about it too much. So you want to make sure that your bank accounts have a designated beneficiary on them. Typically, we would put our spouse or our kids, which is fine. That as long as that account can go somewhere. Because what happens is when you have a direct beneficiary on there and you pass away, your heir, whoever you've listed as the beneficiary on there, will be able to take your death certificate, go to that financial institution, say they go to US Bank and say, hey, Jane Doe has passed away. I am the beneficiary of this account. She told me I was the beneficiary of this account and I have the death certificate. The banker's going to take a look at that death certificate, make sure everything looks good, take your ID, make sure you are who you say you are. They're going to close that account and then write a check to you for that amount or whatever is in that account. That is one way to avoid probate for, say, bank accounts or checking or savings accounts, if you will. Same thing goes for your investment accounts, 401ks, investments, IRAs, all of those investment or retirement accounts will also ask for a direct beneficiary. You can also put people on there as a direct beneficiary. John Doe wants to put his daughter Sue Smith on there. That's easy peasy, do it that way. So when that John Doe passes away, Sue Smith will take that death certificate again, contact Fidelity, Schwab, whoever, say, hey, I know that I'm on the account, that I'm the beneficiary of that. Here's the death certificate. They're going to make you, of course, fill out some forms like all institutions do to cover themselves. And then you'll receive a check from that point forward. Okay, so those are those two institutions that way. Disadvantage of that is that if you named a beneficiary who, say, is younger, you have a 19, 20-year-old who gets an investment portfolio that's worth $500,000. Well, that 20-year-old is going to go buy a Lamborghini because that's what I would do, or a Porsche, mainly a Porsche. But you get the gist of it, that you have no managerial control over how that distribution happens or that transfer happens because it's just a beneficiary. They just get the full amount of whatever your portfolio or bank account is listed. That's the disadvantage of just having direct beneficiaries on things, but it is a way to avoid probate of having those direct beneficiaries. Same thing with a car. A lot of DMVs will have a transfer on death or document with the DMV that you're able to fill out that would transfer that vehicle upon your death. So that is one way, again, to avoid probate. Oftentimes people pre-sign titles, which is obviously not really legal or the best way to do it because anybody could take your title and take your car. But people oftentimes do that as well. It's kind of an old school method where people will just pre-sign titles. Again, not really advisable. But those transfer on death documents do work. They do function, and then that vehicle would transfer that person outside of the probate process. Another disadvantage of that is that you change your mind. You don't want Bob Smith to get your Lexus or whatever when you pass away, but they have that document or that document's already been filed. That's a disadvantage, is that you may have to change that in the future or forget about it, and then that person gets that. Real property. You got a house, you want to avoid probate. You can also do a transfer on death or payment on death document that is recorded with the recorder in that particular county where that property is, and that would avoid probate as well, because upon death that house will then trigger that payment on death or transfer on death, and that property will then be that person. Again, disadvantages that you don't like that person anymore, you've changed your mind. You would have to re-record new deeds every time, or new transfers on death. You'd have to revoke the first one and then file another one, and that can be kind of a pain in the ass, frankly, and can also sometimes mess up the chain of title on that real property. Other disadvantages of having direct beneficiaries on there is that you have younger children that you have listed as a beneficiary on a life insurance policy, for example. Again, terrible idea, just because that minor will now have to have, but usually court intervention, to have those funds placed into a block trust account for them until they are 18 to receive that distribution. They also will need somebody to advocate or to be a guardian for them for that amount as well. Disadvantage again, upon 18, they're going to get that whole lump sum, and you have no real control over that. So you're leaving a $1 million life insurance policy. Yeah, again, we're all getting Porsches and Lamborghinis at 18. So those are kind of some quick, easy ways to avoid probate. The best way, or the way that I prefer, is a comprehensive estate plan with a revocable living trust that provides for contingency plans if somebody were to pass away. If that person for that beneficiary designation is not with us, where would that designation or that transfer go to? That's also a disadvantage, I forgot to say. Is that if you're a person that you've listed is no longer with us, then what happens to that distribution? Their heirs may have to go through probate for that distribution of your probate or estate after you've passed away. So also a disadvantage there. So again, to avoid all that, we can do a nice estate plan that has a revocable living trust. We have a pour-over will. We have all the ancillary documents within that estate plan to make sure that if we do have younger children, that we can provide for parameters on that only at 18, they only get a certain percentage. At 25, they want to continue their education, they can get a little bit more. At upon 30, maybe they want to have a more bigger distribution. At 40, they get the whole amount. So then you're able to control that distribution amount. So that 19, 20-year-old's not getting $500,000. They're only getting, say, $50,000 for school. And then at 25, they want to buy a house, they get additional maybe 50. And at 30, they'll hopefully are responsible enough, and they will then use that money how you would want them to use that money and how it would be intended for them to benefit their lives. So that's kind of the advantage of a good comprehensive estate plan. Also the contingency plan of that if somebody is not with us who is a beneficiary, what happens to their share or their distribution? It'll go back to the estate plan, or it'll go to their heirs, it'll go to whoever you want it to. You have control over that as well. So those are kind of the benefits of an estate plan and getting that set up ahead of time versus hoping we do everything right and trying to avoid probate in other ways, which, like I said, there are ways, but you lack a lot of control and ability to take care of things at that point. So quick and dirty way of avoiding probate besides the typical ways of an estate plan. And if you have any questions or more information, always can follow me on Instagram and Facebook, and also my website at highsierralegal.com. Thanks so much.